I mean, you've read the email from
Yeah.
the. I mean, so firstly, the application has not been processed yet. I wonder how she saw the application because she can't really see applications which have not been sealed, you know. So uh, I've noted it to the registry as well. I've copied all of you in the emails that, they haven't processed the fucking application. She's already listed it.
Yeah.
And, like, the only thing that has changed is that she's seen some videos of me cursing at her. So it's just fucking scandalous, you know. Not because the fact that you have to swear to get matters listed, but because not everybody will be capable of swearing, you know. So, first thing. The second thing is that she didn't check the availability. I mean, only they have said that they're available on the 1st of July. Technically, we had said 30th and 1st of July we could do 1.5 days, but since then, she said that was initially. Then she didn't list the matter, and when I wrote to her on Friday, I said 30th of June, and she's just listed it without checking. And then the third issue I have is that she's listed a Teams thing, and so what I want is an open court hearing, and I want her to publish the link. We'll invite journalists. I'll tell her about that in advance, and we put everybody on notice that there is no fucking suppression order about this, and if the other side wants one, they need to file for an injunctive relief application separately. Which, by the way, Downs can't hear because she's not. She doesn't have jurisdiction until she decides to recusal, and the court cannot be closed, without any real investigation of the appropriateness of the closure. It's an abuse of process-related power, only to prevent abuse and when it cannot be prevented any other way, because a legitimate court doesn't sit except when there's a public hearing. So, and this is not just about whether or not they are getting embarrassed. It's central to the recusal application against her, because our application is that the whole point of everything was for her to illegitimately close the court and prevent us from basically making accusations against the LSB people, which would then, force her to rule against them. That was the whole point.
Yeah.
So if we can't make those accusations again, then how do we argue the recusal application, and how do we argue the I mean, both in terms of the subconscious biases in play and the apprehended. Well, I say apprehended, but you can draw an inference that the logical reason is that she's trying to improperly protect them or protect their reputation in a way that is incompatible with her legal obligations. And now what she's done, it further gives rise to that thing, because on the day I legitimately raised the application orally, she refused to list it without any fucking explanation, and then the reasons she basically, concocted a fraudulent narrative, and then she gives instructions that nothing can be sent to my chambers. I only see sealed documents that come from the, registry, and then in the reasons she notes that the application was not visible on the registry thing. I mean, 8 o'clock she writes and says, the first thing she does is writes and says, this is listed already. Right? Like, before the weekend, we wrote to her and we said, obviously we were anxious, right? And we wanted to know what was going on. And I mean, Lulu and I have fights all the time because she's just going crazy with the stress and the tension and all of that nonsense, which is understandable, you know, because
No, I get that, of course.
I mean, you know, because she doesn't want to be fucking bankrupt. When she saw my video of you, she was just crying and yelling, and I don't. She lost it for a moment because when she realized that the judge was also, you know, out with an agenda, then I mean, this is a bankruptcy thing. You know, it has serious implications for her, for everybody, but for her it means that she'll be kicked out basically of the country. So, anyway, the point that I'm making is that she didn't give a shit about any of those things, and now suddenly she's because of some adherence to rules, which now she's arbitrarily waiving.
Well, I mean, I think, well, one explanation is that she said what she said, and then thinking, well, you know, daring us to do it or not do it, you know.
Yeah, but what I'm saying is it's improper though, right? Like her job is to do justice. It's not to like make it very fucking difficult. And I mean, what she's testing is not whether or not we have a genuine case. What she's testing is whether we will hold her feet to the fire when it comes down to it. That's what she's testing.
No, I agree with that. I absolutely agree, because you know, she's saying we all talk, and are you all talk, or you know,
yeah, but it's so fucking scandalous because, you know, like that's why people say that you know, there's no justice for people without resources or technical acumen.
That's a given. That's an absolute given.
Yeah, I mean,
if you don't have the resources, you're totally swimming against the tide.
And that's why the LSB. I mean, I keep joking about how, you know, what's happening with us is really the backstory to what happened in The Godfather, in the sense that people lose faith in institutions and then they, you know, go to people that they think will be able to speak loudly enough to break through the thing. But I mean, anyway, it's just Thomas called me yesterday. I didn't answer his call. I was busy, but I sent him a link to the thing then. I haven't called him back yet because I want to focus on the thing. Anyway, what I'm saying is that it's just ridiculous. And I read the article again, the Lawyers Weekly. Well, I say again, for the first time actually. Previously I just glanced through it. So that asshole has basically written that Bennett had recused herself only because of she doesn't name Glenn, but you know, she says that there was a disciplined lawyer. I mean, firstly, she's not naming him, and then the only thing that she's saying about him is that, you know, he's a disciplined lawyer. And she says the only reason Bennett recused herself was because of the conflict arising from one of her former clients being a witness.
Well, that's a fairly good reason, isn't it?
No, that's not the point. It's not true. She said that that was one reason. The second thing was she is actually good friends with those people, and she should not be judging applications about whether or not they've committed contempt or whether or not they're perverting the course of justice. She literally says that. I mean, it's in the reasons, and it's just so fucking explicitly fraudulent, the assertion by Naomi Nielsen, that, I mean, you have to, no one can believe that the LSB is not coordinating with her, because
absolutely.
So this is the reason I'm reading the judgment, or the part of it that deals with this. This is LSBB Recusal 2025 FCA 508, and she says in paragraph 25, I'm fortified in this conclusion by the concerns that have been raised about whether a reasonable lay observer could be concerned as to whether I would bring an open mind to the proposed application to cross-examine Mr. Heath and Ms. McLean as to their credit in circumstances where I have a long-standing relationship with each of them. I do not consider it necessary that I canvass the matter in any depth. However, in the context of the matters that I have already analyzed, it is sufficient that I conclude that, having regard to all of the circumstances together, it is appropriate that the matter now be referred to the docket of another judge. She says, I have a long-standing relationship with them, and I should not be judging their credit. So, it's just ridiculous. And then, she didn't mention Mushinsky either, Naomi Nelson, in her judgment. So, it's like, we basically keep making frivolous applications, and it just stuck with Bennett because there was, incidentally, another issue. So, what she's saying is that we had still made the application for an improper purpose. It just so happened that there was a coincidental fact, but the reason for which we had made the application was unsuccessful. That's what she's saying. She's fucking delegitimizing it.
Yeah.
So, and I mean, yeah, it's ridiculous. I mean, I will subpoena her for the main thing, because if the LSP, I say if for the sake of saying if, but it's clear that they are purporting it. If they are spinning this fucking narrative, which they are, then that's another kind of contempt.
Yeah, absolutely.
So.
Yeah, absolutely. I mean,
And I mean, Downs, should be fucking ashamed, because if nothing else, she's being exploited as a fucking tool of injustice. Whether or not she's doing it wittingly is besides the point. Her job is to, I mean, also, firstly, a sensible person can foresee these very predictable things, and I'm not even counting on a sensible person. I foreshadow all of these things. All that she has to do is take the fucking fingers out of her ears when I'm talking. Like, it's, she's so concerned about hearing something incriminating against the other side that she'll have to rule on, that she basically is forgetting that, they don't need additional mob members to lynch us. And anyway, a judge is far too expensive for the process to be efficient. So, like, do you know what I'm saying? Like, if they're just gonna be blatantly against anybody who goes against the government, then they can just have a machine rubber stamp government, decisions, and at least the cost implications of going to the court would not be there for people. So, yeah. Okay, so I'm going to write to her, and I'm going to say that, I'm going to tell her that, Lulu was involved in the business, and now she has a different job, and, well, I'll check with Lulu if she's okay with me saying all of that, but that, because of the overbookings in the first business, she's speaking. She's getting our assistants to deal with them. So we're also not available on the first. And the problem with that booking is that it actually starts this week, and the first is like the last day of it. So earlier, if Downs had told us beforehand, she would have reallocated it. Now it's just impossible for her to do it at the last minute, and I mean these are, people. I'm not sure whether they're actually flying in from China, but they're like, except for one person, nobody speaks English in the group, and there's a number of other issues. So they don't want, it needs to be done carefully. Anyway, so that's one issue. The second issue is that I want there to be a hearing in open court with the link to be posted online for everybody to be able to access it. These are serious allegations being made. Everybody should hear them. And also, I have an authority, it's an uncontroversial principle, but basically anything that's referred to in court, like an affidavit, even if the contents of the affidavit are not completely read, so long as the affidavit is referred to, as in, in that affidavit something was said, it becomes basically read into the public record. Explicitly, like every part of it. So, that is the case with the affidavit of Thomas Flittner, which has been exhibited to my affidavit. And beyond that, we will also make I'll file further evidence about how the, Joanne Jenkins incident is at the crux of everything, and it also, as I said earlier, it's the reason why I think the court is being closed, or the matter is being progressed in a way that is meant to prevent us from being adequately heard. So all those things that we say, people that are viewing the hearing must have access to, because otherwise there's two things that happen. There's curiosity, and there's scandal from incomplete information, because people speculate. And secondly, it's not good for our reputation that where we have evidence, people don't actually see that we were right. Do you know what I'm saying?
No, I totally agree with what you're saying.
So what I'm saying is that we put the.
You know what you're saying. You want that material in. You want to be able to.
No, the material is already in. What I'm saying.
And you want to be able to refer to it.
Yes, and what I'm. Yeah, sorry, that's right. Yes, and I'm also saying that there cannot be any restriction by the registry in terms of open access to that material. So people should be able to get the material through the registry. Like right now, for whatever stupid reason, Justice Maher has made the orders what she has made, and we will comply with them until they're set aside. But so we will, even if we don't circulate the material unredacted, people should be able to get it from the registry without any problems, unless the LSB makes an application legitimately. Because Justice Maher has made no orders in terms of ongoing filing of material in this proceeding. And anyway, the one order that she's made was also problematic, because it was made without affording procedural fairness to the parties.
Sorry, can I just ask a question?
Yeah.
Okay, so what we're saying is that we are entitled to raise these issues in court next Tuesday, right? Okay, and not only that, but we are saying that we want the court to be open, yeah?
Yeah, well, actually, we don't have to say that because it's the law. What we're saying is that
No, we don't. I agree with that. That's what we're saying. We're saying so there is no confusion
Yeah.
or this is what we are saying.
Yeah, what we're saying is that to be abundantly safe, we are putting everybody on notice so they can take appropriate measures. And at the last minute, they don't say, well, yeah, this is how it should be. But now we're in this.
Yeah, no, that's what I'm saying. Is that
we're giving them an opportunity.
Yeah, we're saying our expectation is this.
Yeah.
Yeah. Okay. Yep. Okay. That's clarify that.
So we are effectively putting, and I'm gonna swear an affidavit, and then do it because she's made these stupid directions that shouldn't write to her chambers. So I'm gonna comply with them, and I will write an affidavit and say that the directions that she's made, I'm complying with them, and then I'll rely on those directions to basically seek a determination that they've reached those directions by sending the submissions to her chambers, despite her explicitly saying that they shouldn't, or no one should, unless the subtext was so clear to everybody that it was only addressed to us. Because what she's done is created an impediment for the self-represented party, and then the other party can, basically operate without any formality or constraints. So it's like the opposite of what she's supposed to do. So I'll file, and I will seek leave to, write to her in a way that she reads our emails directly going forward. Because this is just stupid. Like every time we write to her, we have to do an affidavit by, the implication of what she's saying. So, anyway, I think the other thing that I note is that.
Could you do it? I mean, if you filed it as a submission, is that possible?
No, because these are factual matters. How do you assert factual matters without, what I'm saying? Submissions are about either things.
Yeah. We'd be saying that, our submissions would be that when the court's open to, what we've just said. So I'm just saying that as a way around getting the affidavit. I mean, she has to address it then, doesn't she?
I'd rather do factual matters than affidavit, because then.
Okay, no, just a suggestion.
Yeah, no, because I don't have anything to hide, and.
No, I'm not suggesting that. I'm just saying it might be.
Yeah.
An easy way to do it.
Okay, and one other thing. So, I don't know why she's not doing hearings in open court, in the sense of physically in the court, because. I mean. The team doesn't. Yeah, that's another problem. I think normally judges fly to the place where they're holding a hearing.
Not. I wouldn't think for a half-day hearing she wouldn't move.
Okay, yeah, maybe not for this one, but there are issues obviously that I have with doing it via Teams. One, if she wants to shut me up improperly, she can just fucking disconnect or mute me. And I don't want that. Like, if I'm misbehaving, then she needs to charge me with contempt and not fucking silence me. I mean, it's just, the common law did not anticipate the muting of people, so there aren't protections built in. I want to be in court, and then if she has a problem with what I'm doing, if I'm interrupting, there's a, contempt of court charge that arises from obstructing the due process of the thing. But I've had enough experience with Gorton and his disciples to anticipate these things in advance. That's the first thing. The second thing is that the other side needs to come to court and feel the fucking pressure of being in court, because it's a sobering influence, and all the tactics that they play, that's the whole point of the court environment. It's supposed to sanitize against.
No, I understand. Yeah.
That's the thing. So I'm gonna ask for a court hearing, and I mean people can also attend. That's how it should be. And okay, not that it's relevant in this case, but I think in her not scheduling a hearing in court, an inference also arises that she accepts the um, sincerity with which I'm criticizing her, in the sense that because she's a judge of a superior court, there is a presumption of correctness in relation to her decisions that arises. It is a natural implication of that presumption that a person who calls a judge what I've called her is basically committing contempt of court. If that has happened, then it's clear that she would have been required to hold the hearing in court so I could be at least charged by the pathonetry or whatever. Given that she's done none of that, it means that she's implicitly accepted that there is no basis to, determine that, well, to charge me. But I mean, obviously there isn't, because she's everything that I've said is thorough, and I can prove what I was thinking at different times, and the recordings catalog that well. So I'm just saying that they're not thinking about much, like they're just reacting instinctively and just trying to, mitigate their personal liability effectively. So, do you have anything against like being in court? I know it's going to be inconvenient, but I think it's necessary to prevent them from playing tricks. Also, you don't have a great. I mean, I'm not saying this in a critical sense, but like, I think sometimes you have internet issues where you are. Plus,
no, I mean what you're saying. I don't have an issue about going to court.
Yeah, and I think the other thing is that, like, if you're on your own there, you're less. You're going to be disadvantaged than if you were in court and you had the documents. Like you're not very. Do you agree with one?
No, I don't agree with what you're saying, but I'm happy to go to court.
Okay, all right.
You don't have to come up with reasons.
Yeah.
That you are relevant, because I don't. But anyway, I'm happy to go to court.
Okay.
The only thing is, half a day. Well, that's not going to happen.
What do you mean half a day is not going to happen?
No, as in half a day she's allocated.
So 1st of July, I'm going to say we're not available.
Yeah.
So we will ask for an alternative hearing. Is there any other date that you're not available? Like.
The only. Look, as a rule of thumb, it's a lot easier for me during the week because it's not busy as in Fridays to Mondays.
So I can say that.
Tuesday, Wednesday, Thursdays are much better.
I can say that it would considerably affect your convenience if the hearing was not scheduled. Well, if it was scheduled between Tuesday and Thursday,
yes, rather
than Monday and Friday, I can say that. But is there any hard unavailability?
Any hard unavailability? No, not that I can think of.
Okay, so the first is a Tuesday, by the way.
Yeah, I knew the first was Tuesday. Yeah.
Okay. All right, and then I think everything else I've covered already. Do you have any issues with what I've proposed in terms of writing to her?
No, not really. I mean, the old story. I don't know how much is going to end up helping us, but if she goes, great. If she doesn't, well, we're just in the boat. I know that you'll say we'll speak without caves, etc. But
no, but how can she not go? How can she not?
Yeah, no. I'm just saying we'll see, won't we?
No, I mean legitimately she cannot stay. If she, Peter, you can only make plans based on the legitimate enforcement of your rights. Technically, they can hire goons and get us all whacked outside court, which, by the way, would be cheaper than what they're currently doing. And
Yeah. I mean, look, I'm keen that we file the appeal and get it.
and we're doing that, but the
Yeah.
the problem is that they have basically prevented us from raising some of the allegations as well in the appeal, effectively. I mean, I'm happy to do it that way, but Lulu, for instance, is very uncomfortable in mentioning about the Joanne Jenkins and all of that stuff in the appeal, which goes to the. And I mean, I'm not sure what your position is, but anyway, I'm not saying that we can't lodge the appeal necessarily without that, but what I'm saying is that these things are affecting the progression of all events, and also it's a distraction for us from doing the job that we have to do with the appeal too. Okay, but one other thing that I wanted to say is that yeah, okay. The other problem that I have with her is that so
Yeah, with who? Sorry.
the Downs, Justice
Yeah.
Downs,
Yeah.
it's that the application that we had made, we were only seeking orders 1 and 2 to be heard immediately, and sorry, the application in relation to orders 1 and 2 to be heard immediately, and then basically the expectation was that she would recuse herself, and then a new judge would be appointed, and then there should be a directions listing, and then a decision about all the other things. She has basically indiscriminately listed the whole application for hearing on Tuesday.
Yeah, I understand your point.
That's a absurdity. Like we haven't even, we're not prepared for the whole thing to be listed, and then it cannot be heard in one day, half a day anyway.
No, that's what I said earlier. It couldn't be heard in a half day anyway.
And so if she doesn't recuse herself, she has to issue the subpoena then on Tuesday. That's the first thing we asked for. We asked for her to give us leave to issue subpoena to LSB about the communication with Gorton and Forbes and the platometry in the Supreme Court.
Yep.
And we asked her to give us leave to issue subpoena to at least Thomas Flitner and to Matthew Anstey in relation to their, Matthew Anstey, because he's the one who's given the hearsay evidence that, what's his name, Heath has relied upon. And obviously Thomas Flitner, because he's the witness that we have for the stuff. So, so we ask for that. I'll foreshadow it as well.
No, I think that's more than appropriate. There's no way, no.
Yeah, but I mean, she can't legitimately stay. This morning, Lulu was like, "Can you write to her and ask her how she said that it was an ex parte communication?" She says, I still believe that maybe the associate got it wrong, and maybe she was under the wrong impression, and blah blah blah. I mean, it's just bullshit. It's clear what has happened, but I told her to do an affidavit and file it in the thing, and then she is supposed to address it in the reasons. But there's no way, after everything that she's done, that she can stay, because at the fucking very least, she needs to charge me with contempt. Because if she says, I'm gonna say more stuff, because she will deserve me saying more stuff. And then, what's the basis upon which she's taking abuse just to stay in the proceeding? Yeah, she has to give it to the. The Gordon experiment didn't fucking work. And we already had developed tools in real time as he was doing it, but now we're ready with the stuff that needs to be done to deal with it. So it's the hearings are in open court. We will file the appeals or injunctive thing, but if she tries to, I mean, she has to address every point we raise in the submissions. Sorry, in the affidavit. Gordon, the only way he avoided the explicit acceptance of things was because he basically ignored everything. There's no legitimate way of addressing everything and then, staying in the matter. And by the way, it would be contrary to what Bennett did, and it would be contrary to what Mushinsky did.
Yeah, no, I hear what you're saying.
Because think about it, Mushinsky.
I mean, the non-contact community changes. They're quite ridiculous.
Sorry?
Yeah, I mean, she's done a lot of things. Regardless of her reasoning, and I think her reasoning is this: is that she obviously has some insight into what you do and how you operate. So she's trying to get on the front foot, as we say, and stop you doing what you normally do.
Which is completely fucking lawful.
No. I'm just saying that's what clearly that's her intent.
Yeah, well then she's not a judge, is she? She's a fucking mercenary for the other side.
Yeah.
It's no different from taking a bribe from the other side. Like, it's basically a transaction that is meant to give them benefit, and it's not because of any other reason but for the fact that they're a government body, and she'll benefit from that. So it's, she doesn't stop me from making applications. She rules on the applications I make. That's the law.
Yeah, no, and that's as I said, I think she's trying to say to us, well, if you're going to do it, I'm going to make it a little bit harder for you to do it.
Well,
that's what she's done.
She's actually made it easier for me. I mean, she's created more nuisance for you. For you guys.
In her mind, that's what she...
I know that.
Yeah.
But what I'm saying is that it only works if the other side is half fucking committed.
Yeah. No, I totally agree. That's why I think she's, that's what she's done. That's why she's done this sort of move to actually determine that.
There is no way she can explain all the things that she's done. And again, the threshold for the recusal in Australia is not a very high bar. In common law, it's not a high bar. It's just that one reasonable person should agree that what she's done gives rise to a concern that she will not judge the case completely impartially. I mean, you don't even have to have a apprehension. She's literally reading their emails and ignoring ours. That's it's demonstrated disparity. You don't even need to demonstrate that it may happen, because it's already happening. And she's not giving reasons for anything, not addressing critical factors, and then accusing us of things that the other side is not accusing of. I mean, forget about the fact that we've not done it, but even the scoundrels on the other side who have made all sorts of incendiary and spurious allegations against us wouldn't stoop to that level. And she's accusing us of ex parte communications. So, and because it delegitimizes our moral authority against the LSB. So, okay, I'm gonna put that in the affidavit and then file it. I'll try to do it by the end of the day, but definitely by tomorrow, because I want to cover a fair ground. And then I'm gonna say I'll check with Lulu, but you don't have any hard unavailable dates between the 1st and the 18th, and
no, not any. No, not any.
Okay, I'll check with Lulu, and then if she doesn't, then I'll convey that. And then I think everything else is sort of fine. I think I will get Lulu to give evidence anyway with the recusal application about the stress and the other things. You may want to consider if you want to give evidence as well about the impact all of this has happened. This is having on you, because I'll say that like you may want to give evidence about that. Yeah.
Yeah, I don't have a problem with that.
So, but preemptively, so scheduling wise, she can think about how much time may be appropriate. So I'll say that, and yeah, that's really it. Okay, thank you. I'll keep you updated, and
Later.
yeah, speak later. Cheers, bye.